Welcome back, everyone. Before I introduce our next speaker, I would like to follow up on a comment that Kirby Payne with HVS Asset Management Group mentioned, and it's in the chat, but I do want to emphasize it, that they share with the guests that they need to come in each room every day to empty the trash to justify their coming in. And keep in mind that a do not disturb sign is not a legal preclusion. It's a guest request. It's just a customer service management issue. And my preference still is that we get into our guest rooms every day for all of the reasons we've been speaking about. Kirby, thank you very much for that very insightful comment. So now let's talk about some labor and employment challenges that we have coming up. And we're going to be joined by Andria Ryan, partner in Fisher & Phillips. The Fisher Phillips law firm is a labor and employment law firm representing the employer's interests nationwide. Andria has been focused on labor and employment since 1988. She co-chairs the Hospitality Industry Practice Group, and she's a member of the firm's COVID-19 task force. Many of you have heard Andria before at our conferences. She was also a featured speaker at our phone calls that we did for the industry throughout COVID, she and other members of her team. Always a pleasure to have her joining us. We've asked her to speak to you today, kind of do double duty, so I'm going to get out of the way. First on the vaccine mandates, and then about some of these employee staffing challenges that we're having. Andria, welcome.
Thank you, Steve, and it's always nice to be back here. I would add to my resume that I'm now a member of the COVID-19 vaccine subcommittee. Who knew this would be a resume enhancer after 30 years of practicing employment law? But we are moving in that direction.
Andria, would you prefer to do your own slides? I can exit out and let you if you would like.
No, go ahead, Taylor. You can stick with me. Go ahead and show the first slide. When I originally talked to Stephen and his crew about a topic, we were, headed out of COVID. We were going to deal with some staffing shortage issues, and I wanted to concentrate on the legal minefields. And I reached out after President Biden announced his intent to have OSHA issue a federal mandate for COVID vaccines, and said it just seems like the group needs to talk about this. So we'll pivot from one to the other, and we'll do a little bit of COVID, and then we'll talk about the staffing shortages, which of course COVID is affecting as well. So Taylor, let's go. On the COVID vaccine mandate, President Biden's plan involves OSHA issuing an emergency temporary standard. On my slide, you'll see it referred to as an ETS. And it will apply to all private employers with more than 100 employees. And the main requirement is to ensure that your employees are either vaccinated or tested weekly. And I'll talk a little bit about what fully vaccinated, mandated, and tested weekly might look like for you from a logistics standpoint in a moment. It had a number of other requirements that don't necessarily apply to hospitality employers, but it will likely require you to provide time off to get vaccinated, and also time off if an employee suffers some side effects from the vaccination. We estimate it'll impact 800 million workers, 2/3 of the country's workforce. I know many of you in the industry have waited to issue vaccine mandates. Many of the clients I work with said, we're not doing it until the brands do it. The brands haven't done it. So we're dragging our feet as long as we can. So unfortunately, we may get dragged kicking and screaming into a mandate. It will take the form of an emergency temporary standard. Significant citations and penalties, up to $14,000 per violation. And I'll preempt the question, is it per person? Is it per failure to vaccinate? It is unclear to us at this time. And in fact, much of what I'm going to talk to you about in this session is what's unclear, but hopefully give you some guidance and let you start getting a little bit prepared. So Taylor, our next slide talks about when we expect the ETS will likely be issued. We are speculating here, and we're doing a little bit of putting the pieces together. When is the OMB, the Office Management Budget, likely to look at this, and what's our expected publication date is October 18th through the 20th. We're looking at an estimated date. We have no information about this. It could certainly change. But with a pretty quick effective date, and then an enforcement date of October 27th, and then an enforcement date, a full month out. One thing I want to say about enforcement is OSHA is already understaffed. They are trying to staff up. Anecdotally, they are saying to our folks that work with them closely, we do not have the manpower to enforce this standard. And they are also concerned about security because they're starting to get security threats from some folks that are opposing this federal mandate. The ATS will have effect in 29 states where federal OSHA has jurisdiction, and in those states that have state OSHA jurisdiction, where the feds don't have jurisdiction over the workplace safety laws, those state agencies are going to have to adopt a ETS or just as effective measures within 15 to 30 days. So this will be a nationwide standard and probably likely consistent. An emergency temporary standard is in place for 6 months before it must be replaced with a permanent OSHA standard, which is why it goes through, when it'll go through the normal rulemaking process. An emergency temporary standard does not have to go through the normal rulemaking process because OSHA must prove that there is a grave danger to workplace worker health and safety in the workplace. So our next slide starts our unanswered questions. And I guess I'll apologize in advance because I'm going to give you a lot of this is still unanswered, but let's talk a little bit about that. As few employees as you have that work remotely in the industry, although Stephen would say we should be more creative about some of those. It's unclear whether remote employees will be covered, although OSHA did come out about a week after President Biden's announcement and had some stakeholder meetings and said they do not think the ETS will apply to employees who never come to work. But if an employee ever comes to work, comes in for meetings, works with others, works with your customers, does site visits, they will be covered. And I will say the $1 million question is, how will this 100 employee threshold be counted? It's a $1 million question for a lot of industries, but especially this one. OSHA officials have suggested that it will likely be more total number of employees employed by a company versus employees at a work site. This is going to make a big difference for management companies, for owners where we have common ownership of several properties. We expect more clarity on this particular issue from the ETS. We expect some of the same standards that apply for many of the other laws the Department of Labor enforces, like the FMLA, where things like common ownership, common control of labor relations, those are the sorts of factors that will be looked at. And it's also unclear how the joint employer analysis will factor in, which again is always an issue for our hoteliers and restaurateurs who are using contract labor on a pretty regular basis, especially in today's understaffed world. A couple of more unanswered questions on the next slide. Will you be required to collect proof of vaccine, and how? It's unclear at this time, although we will be surprised if there's a mandate that doesn't have a specific requirement on the collection of the information, and whether that means an employer can keep a spreadsheet without keeping the actual vaccination record card, or whether they'll need to keep a copy of the vaccination record card. This has already posed employers a lot of angst. It feels a bit invasive. There's many employees that don't like it. In fact, anecdotally, I have a number of clients who think they have employees who have actually been vaccinated that just don't want to provide their vaccination card. The other thing we need to keep in mind is OSHA has very significant record-keeping requirements. So it's really, those are the longest record-keeping requirements of all the employment laws. So if there's a record retention requirement under this mandate, it's a 30-year retention. So huge record-keeping implications if this is required. And then what type of testing? That's unclear as well. Are PCR tests going to be required, which are more reliable? Are rapid tests going to be permitted? Are at-home tests going to be permitted? We'll see. So look out for this issue as well. And so I would start thinking about some of these logistics. Are you going to do on-site testing and have a clinic come on board? Are you going to administer them themselves or ask employees to self-administer. It's all still out there for us. Who pays for the testing? Again, unclear, although our best guess is that employers will be required to pay for any kind of mandatory medical test. There are some states that already require it, and we suspect if it's a mandate of your continued employment that you'll be paying for the tests. And as we see on the second bullet, likely going to be paying for the time to be tested. OSHA has commented in their public comments that employers will be required to provide paid time off or allow the use of PTO. But for an employee who does not have that time, you may be out of maybe an employee, may be on the clock for this testing. So generally under the wage and hour laws as they apply now, and time spent by employees receiving employer mandated tests, drug tests, for example, is compensable time. And so now start thinking about, are you going to do testing during the workday? Are you going to allow employees to do it off site? How are they going to clock in? Do you have the capability of having employees capture that time? Start putting that on your radar. And Taylor, on our next slide, will another $2 million question, how about that? Will the ETS face legal challenges? And I think that's for all of us on the call here, it's a most likely. Governors of several states have already indicated they intend to challenge it. And we've seen this before, right? We saw it with the Fair Labor Standards Act. We've seen it with healthcare. It could get blocked completely. It could get parts of the rule could be blocked. We're not counting on it. Again, the standard that OSHA will have to prove is that there's a grave danger to workers. And so, as you can imagine, we're going to see, are the numbers going up? Are the numbers going down? What parts of the country? I think a lot of arguments to be made. But we don't think employers should really count on being relieved of these obligations and start preparing now. So what does preparing look like for you? Start thinking about what your procedures look like. Start communicating to your leaders. Don't let them be surprised. Ask them to be patient. Ask them to tamp down the political discussions and the likely controversial discussions that are going to occur about this. Ask them to be good leaders and be positive. You are going to have to maintain confidential records. So how are you going to maintain them wherever you're keeping workers' comp and other medical records, that's a likely secure place for vaccination records. It is lawful to ask employees about vaccination status, but that should end your inquiry. Are you vaccinated, fully vaccinated or not? Here's the definition of fully vaccinated, yes or no. No discussion about why not. There may be times where we have to go a little bit further if an employee asks for an exemption, but the inquiry today should be simply yes or no. Again, we may have to collect proof of vaccination or create a spreadsheet of confidential vaccination status. And please take a look and consult with counsel on confidentiality and privacy of medical records in your state. Some states have very strict rules, others not so much. And so we'll want to layer those requirements on top of the ETS. And then think about whether you're going to, this dovetails into my very short staffing discussion we're going to have in a moment. But will you mandate the vaccine or will you allow unvaccinated employees to be tested weekly? Obviously, the federal government is pushing us to have a vaccine mandate. I will say logistically, it's a lot easier if you just mandate the vaccine. Will you lose employees? You will definitely lose employees. They will go to employers that are smaller, that aren't covered by the ETS. You will lose employees. But if you plan for weekly testing, you've got to start thinking through the logistics. I'm working with a client this week who has 600 unvaccinated employees or employees without proof of vaccine out of 2,000. And they're thinking through, many of them are on call. So we think many of those may have vaccination records that we just don't happen to have. How can we go about collecting those? And if I whittled the number down to half, maybe I have 300 unvaccinated employees, how am I going to plan for testing 300 employees and tell my leaders and managers, you cannot put them on the schedule until they produce a negative COVID test? And what does that weekly schedule look like? Who's tested on Mondays and who's tested on Tuesdays and who's tested on Wednesdays? And who's going to collect the results and how will they be collected and who's going to communicate the employee status and track the results. So the logistics are not overwhelming, but certainly challenging. You need to have a plan for addressing non-compliance by employees. It's a safety. If you decide to either either require the mandate or do it the hybrid vaccine or testing, what happens to an employee who doesn't get tested, who refuses to get vaccinated? This is a safety rule, and it needs to be enforced. Obviously, for disciplinary reasons and for OSHA compliance reasons as well, if the ETS stands. One of the things I'd urge you to consider is perhaps giving an employee a 48-hour administrative leave or whatever you want to call it to think about. Here's our requirements. We urge you to, we'd like to keep you, we'd like to retain you, spend 2 days, 3 days, whatever you decide, to think about that and come back and let us know. Some states are already indicating with their healthcare workers that they're going to disqualify them from unemployment benefits for failure to follow state vaccine mandates. So there's that to consider as well. And then another hurdle that I want you to start thinking about is to develop a plan for handling accommodation requests. Employees may request an accommodation from a vaccine mandate for their disability or for a sincerely held religious belief. There are some medical conditions which would prohibit an employee from getting vaccinated. And there are some religions or religious reasons that employees are articulating. Some seem a little bit out there, but they are articulating them, not all, but some, to be exempt from the vaccine. Obviously, an accommodation to that would be weekly testing. I mean, the government's going to give us that option in the ETS anyway. But let's develop an accommodation policy where employees can ask for the accommodation, demonstrate their need for it, either with medical note or some description of their religious belief, and then administer that process thoughtfully, individualized consideration, grant or deny the request, and if you're granting the request, what are the requirements for that employee going to be moving forward to stay employed and stay safe? And then Taylor, to pivot to the issue of staffing shortages, which was my original topic, there's a lot of options out there. I heard a speaker today at a state hospitality conference the day before yesterday who said, we've had staffing shortages in this industry for a long time. They are a little bit exaggerated right now, but we've had staffing concerns. And of course, COVID is layering another challenge on top of us. But what we're seeing, and this is just a handful of them, but what we're seeing in terms of people taking advantage of some other options are these. We're looking at app-based placement services. How handy is that? Gig pay, early access to their earned pay, daily pay, sharing employees, taking advantage of trained employees, giving them the flexibility to work different shifts at different properties you may own or manage. Flexible scheduling. Our younger generation is all about flexibility and taking advantage of non-traditional workers, students, caregivers with school-age children, and then pay and benefits. Benefits for part-time seasonal workers. Many hoteliers have never considered that, and they're now putting that on the table. So we're trying to be creative about staffing shortages, but they come with some risks. And in my next slide, I just simply raise a handful of them for you. Wage and hour, always at the top of our list as employment lawyers, isn't it, right? Extra pay must be included in the regular rate for overtime calculations. Keep in mind that if employees are working between properties that you own or manage commonly, you may be creating an overtime issue that you hadn't anticipated. They can't, their time may be included for purposes of calculating overtime at working at both locations. You want to consider the misclassification issues, whether somebody, a gig type worker or a regular staffing contract worker is working for you for such a regular period of time that we have some potential joint employer issues or some supervision issues that will raise joint employer issues. Be mindful of the states with predictive scheduling laws. On the one hand, using gig type workers and app-based staffing falls into some of the exceptions that these predictive scheduling laws have, where you have to give a certain amount of notice before you change someone's schedule. So if you have an app-based, gig worker that can fill in at the last minute, may be able to solve some of your predictive scheduling laws, but you also want to make sure you're complying with the predictive scheduling laws as you're using those folks. And one issue I want to raise, and I call it background checks and performance issues, but we don't want our regular employees to have to suffer working with contract staffers or app-based temporary staff that are untrained, that are unsafe, or poor performers. They drag the entire team down. So I'd urge you to do a lot of vetting if you're going to use one of these services. What kinds of background checks do they do? Does it meet your standards? Are you comfortable with the level of background checks that folks are doing? Are they hiring folks that are unhireable elsewhere, or are they just simply hiring folks that want the flexibility of an Uber type situation? And performance issues. The best systems that we're seeing are those that will allow you to rank and look at the rankings of these workers. Do they show up when scheduled? Are they a 5-star Uber driver or housekeeper, or are they a 2-star housekeeper? I think there's really some value to be able to evaluate other people's experience or see other people's ratings and experience with regard to particular workers. So again, it's a topic that I hope to return to soon with Stephen and one of our next sessions together. Vaccine mandates sort of overtook everything. I would urge all of you, I'm very proud of Fisher & Phillips, our team at Fisher & Phillips. When COVID hit, we really hit the ground running. And we have developed a very robust landing site where you can go and get forms and sample policies. And we're putting alerts out about every change the CDC makes, and important change, obviously, and the government. And so keep your eyes on it. We will put something out very quickly about this ETS, the Emergency Temporary Standard, when it's issued. So please feel free to just sign up and get our alerts at our landing page here. But we're COVID heavy right now.
Well, thanks, Andrea, as always. And wow, 2 topics in a very short period of time, but great insight. Thanks for these suggestions on getting prepared now, even though there are so many unknowns. I think those are very helpful. And I had actually written down a question for you, which is, Andrea, it sounds like we're much better off just having a vaccine mandate, but I think you probably answered that question with with all of the challenges with testing. Oh my goodness.
Yeah, I think the logistics, I mean, if you think about it, there's no situation where employers, hoteliers for that matter, are doing those kinds of regular testing. I mean, other than random drug testing, which very few people really do nowadays, that's just not something that we're geared or prepared to do.
Yeah, you're exactly right. All my hotel folks tell me if they tested for marijuana, they wouldn't have any employees. Maybe we need to get Kristen back to talk more about cannabis in the conversation. Andrea, we got just a few minutes, but I want to step back to the hotel staffing contracts. You talked about vetting. How are they vetting, right? What is that looking like? Performance rankings, things like that. But in terms of some of the terms and clauses that are included in these staffing contracts, I don't think you touched on this today. I know we've talked about it a little bit previously, but are some of those more onerous, some that you have seen in reviewing for your clients that people in this Zoom need to know about? I'm thinking about indemnification. I'm thinking about responsibility. I'm thinking about litigation as it goes forward, right? So can you, and I know that's not your specialty. Yeah.
I'm glad you raised it, Stephen, because we're all using staffing agency, or I presume most of you are using staffing agency. And interestingly, we're relatively sophisticated with our contracts. We draft our BEOs, right? We prepare, they're prepared for our benefit for the most part. We don't do that with staffing contracts. What we seem to see is our executive housekeeper signs some 1.5-page contract that all anybody's concerned about at the time it's signed are the wage rates and how many folks they're going to get us, and nobody's really looked at the contract. I think you should have your own contract. This is what our staffing agency agreement looks like. Our terms in terms of our the pay rates and those kinds of things are all negotiable, and they are an addendum to the agreement. But have a staffing agreement that protects you, that deals with proper indemnification for you and the staffing agency, that tells the staff, that requires the staffing agency to comply with the laws, including the immigration laws and the wage and hour laws, that has a cooperation clause that both parties agree that in the event of a harassment complaint or request for an accommodation, that we will reasonably work together to try to resolve this, within the bounds of the law. It doesn't have to be lengthy, but I'm always surprised at how quickly we sign relatively unsophisticated staffing agreements. So I want you to centralize them and give yourself a little bit more protection. It's a good point, Stephen.
Yeah, I'm glad you mentioned that, and I'm glad you shared that with them, because I do think it's important. These contracts, even though they're short, they can have severe consequences. So you need to vet those carefully as well. And here's the other thing: a lot of these businesses have gone to digital contracts, which I'm a big fan of, right? But they look very short, but they'll have a little bitty notice in there about subject to our terms and conditions, which when you click through to those terms and conditions, my experience has been that they are some of the most onerous, one-sided terms and conditions that you can see or we've found or experienced. So I hope everybody is mindful of that as well.
Sometimes incomplete. I have a client that I worked with many years ago, and you don't have to raise your hand if you happen to be on this call, but that said, I'm going to get all my independent contractor, everything that's out there, from staff to culinary and housekeeping, everywhere, the golf course, everywhere. And I'm going to get them all together. I'm going to see what I have and try to get my arms around this and get more protection for us. And just finding them was an unbelievable challenge for General Counsel's office. Just finding out what had been signed out there.
What a great point. All right, everybody, you've got some things on your to-do list for sure. Any other questions for Andria? We've got just a minute or two. They come through the chat. Let's see, Andria. I don't know that I'm actually connected. Andrea, if you see them, please.
I'm not seeing any questions.
Yeah, as you can see, my video image has ghosted me, so I'm not sure that I'm totally good. We're having some Zoom challenges today. We'll have to work on those.
We'll all look forward to seeing each other in person next time. It'll make us appreciate it just a little bit more.
That's a fair point. Thanks for that. Andrea, thank you. It's always a pleasure to have you joining us. Tell everybody at the firm. Yeah, you likewise.
See you all soon. Thank you all.